I tried to ask what they talking about. You get your phone, Divine. Bring your phone in here.
No, leave your phone out.
She can hold on to her phone.
No.
You can hold on. It's a container that you can hold on to her phone. She came to get her phone and she ain't hanging.
Come on in there.
If y'all gonna have her, she ain't hanging to talk about she a friend. But I don't know her. I still can raise my children.
Put the water down there.
We're right here.
One of these chairs.
Terrell down here. Is Terrell's attorney here? Why is Terrell's attorney not here? I don't know what to do. Pay attention. Listen. You are not sick.
All right, what are you saying?
I am not sick.
2014 P45 in the interest of wrong case number, 23JC150 in the interest of Tyrell Morris. Appearances, please. Chelsea Phillips from DCFS. Your name, ma'am?
I'm Jasmine Renee Davis.
Thank you.
I would like to keep
Tyrell
my name.
appears in person and with counsel Gregory Davis.
Behind the rail, please, loudly.
Barry Renee Lee, and along with my grandson, Tyrell Morris.
Thank you. You need to use the microphone. Divine Davis.
Those are my children.
Ma'am, in your connection in this matter, ma'am? Okay, thank you. All right, the sister. Okay, ma'am, I know that you're talking, you gotta wait your turn to talk. I'll give you the opportunity, but you still have to not interrupt. Okay?
I have my parental rights.
I understand that. I'm just telling you, you can't interfere with people talking, but you get your own, you'll have an opportunity. but we just have to have a certain orderly fashion which everybody speaks. And the court reporter can only take down one person at a time, and we need to have an accurate record. So with that, we are here today for a permanency hearing. Ms. Wilson,
we are asking that the both of reunification and guardianship continue for Tyrell. He is currently in care of his grandmother, and she is a relative. We are working with her on needing to become foster care licensed in order for us to be able to consider moving forward on something like a guardianship. In terms of reunification, we have not been able to successfully meet with Ms. Davis at this time since the last report. We're still in attempts to do so. There's a scheduled meeting for this coming Monday at 9 a.m. We have had difficulty getting her agreement to work with us on these things in her court orders. We believe there's also a revision on today to formalize that Ms. Davis has not engaged in visitation planning and has not seen her son since he has entered foster care. To my knowledge, not formally set up through DCFS, and so we would like there to be formal recommendations that need to be met to ensure that any visitation would be safe and appropriate for Tyrell.
and thank you for bringing that up, because we are also here on a request to revise the dispositional order. So, Attorney Allen, what is the state's position on everything here?
Thank you. In regards to the request to revise and to order conditions for reinstatement of visitation, we are in agreement, as noted by Ms. Coates. There has not yet, at least to our knowledge, been visitation with Tyrell, Ms. Davis, in foster care. The conditions for reinstatement of visitation, I believe, are appropriate. The only caveat I would give is that the request is for a period of 90 days of compliance with the recommendations of psychological evaluation.
No.
As we discussions with Ms. Stokes prior to this hearing, I believe that it would be appropriate for 90 days of compliance with any therapeutic recommendations of the psychological evaluation. In regards to the permanency plan, I do believe that the continuation of the dual goal for reunification and guardianship is
I'm not thinking of that.
unfortunately, there seems to be very little contact with this Jasmine and DCFS. There appears to be some digital communication, although my understanding is that those have not been productive. In regards to the father, Mr. Morris, he appears to be largely disengaged. He's expressed that he feels incapable of being a full-time father to Tyrell. I would note that by the permanency plan, Mr. Morris has previously been a source of support to Tyrell through some periods of significant visitation, including in the early mornings, showing up to help Tyrell get ready for school. But that's fallen off in the last few months. So I would ask for the court to adopt the recommendations of DCFS in both of these matters.
Okay, thank you. Before I continue on, Ms. Lee, did you want to make any comments as to how Tyrell is doing?
Right now,
Use the microphone, please.
Oh, I'm sorry. Right now, Tyrell is doing great. He's doing good in school. At home. I just need a little more help with the one-on-one that he has in school. Me and Chelsea have been talking about that. His personal care that was coming to the house. She didn't show up for the whole month of December or January. Selena, with the program he's in, they're working on now getting someone else to come assist him with that, because that's a service that we really need. We talked about that last time we were here. Overall, he's doing pretty good. He's learning more. He turned 13 in December. Overall, he's doing real good.
Okay, thank you so much. I appreciate your caring for him at this time. Attorney Bates?
Your Honor, regarding the permanency plan and goals, we believe that they are appropriate. Terrell is doing well in his current placement. Grandmother should be thanked for her assistance in this matter and keeping him safe under the circumstances. Hopefully the guardianship can move forward soon, but right now we believe that the dual goal remains appropriate. Regarding the revision, take no position on that. I haven't seen any psychological examinations, so I'm not aware of any recommendations there, but we take no position on that.
Okay, thank you. Did Tyrell want to make any comments?
He's fairly nonverbal.
Okay. Just didn't know if there was anything at all, so that's fine. Okay.
Does Tyrell want his mother? Ask the questions.
You're looking pretty handsome back there, young man. Thank you. Thanks for coming. It's great to see you. All right, Ms. Davis, what is your position on the permanency goals as well as the request to revise the order? I know in the beginning, before we went on the record, I think it was right before, it could have been right after, you had said, I still have my parental rights, nobody's trying to take your parental rights from you. So I just want to make sure that you understand that. That's not a goal here. But what would you like to say, ma'am? I'm just going to also ask if you would speak slowly and into the microphone.
Hi, Jody Elmore. My name is Jasmine Renee. I would first like to ask, when you all refer to me as Jasmine Renee Davis. I know that I can say that you did say in July that Chelsea Goats is supposed to work with me on the permanency plan. She has not did that. She has refused. She did not tell me, she did not make a meeting to even discuss the permanency plan ever. I have never had the opportunity to even put any input at all. The permanency plan is all of assumption, never a statement from me ever. I have never managed a McDonald's. I have never attended the University of Wisconsin Parkside, or a lot of things on there that she has said is not true. Chelsea Ghost has run out the clock. I have multiple emails that Sheriff Garcia is attached to, Brian Scheffler, the District Attorney's Office, the FBI, also Gregory Bates, and now the Clerk of Courts, the Sheriff Department. I have over 20 listings here that I have attached that have been following this whole thread of emails. I have been trying, I just submitted some stuff to the courts downstairs right before I came here. I have been trying to meet with Division of Children and Family Services about my son. I also have asked so many questions that they are refusing to answer, so that I can at least know for my investigation, so I can know where they are, so that I can talk to them and have a conversation with them appropriately. And they have refused, saying they don't want to have a conversation through email. And I've been emailing, and I said to them, I believe it was a couple months ago, perhaps, I don't know the exact date, but perhaps November, December, something like that. I said, you all are trying to run out the time of the clock so that I cannot see my son. They keep replying with very minimal, just generic replies to me, or accusing me, or saying something, and then they don't reply back, so that they could just get over with what I'm saying. And then I emailed them probably no less than one time out of the week.
Okay.
And I said to them, I want to meet with my son constantly. Then I asked, well, how can I? What am I supposed to do? How is it supposed to go? They replied to something totally generic. Then I said, like this one here, I said, this was on October 24, 2024. I said, I am Jasmine Renee Davis. The email that Chelsea Ghost sent to me was contradicting to the fact, truth, and many laws. I have interest in keeping my parental rights. Okay, I'm trying. Okay. And you know what? Black literacy is very important, especially with the school to prison pipeline. Especially with the school to prison
Okay,
pipeline.
stay on task here.
Is there a list of rules of how I'm supposed to speak about it?
I need you to focus on the
You
issues
told
for
me to
this.
slow down in reading, so I was just really proud of myself there.
Yeah,
Because
you
it
did
is
well.
a challenge. And
Okay.
so I have the literacy to read, and it's not easy.
Okay.
There is a school to prison pipeline, and this is included.
Okay.
I have interest in keeping my parental rights and seeing my son and being involved as his mother without interference and false accusations and crimes to me especially. Okay? That was Thursday, October 24th. Also, I did say, I also was even requesting for information for a panel, to bring things before a panel, which Jen told me that in your courts, told me that I request that with the Division of Children and Family Services. Chelsea Ghosts have been denying everything on every single term, but I asked them, okay, and I even said, please, I am saying please, okay? I have another one, Wednesday, November 20th. I just printed out something. I want my son, Tyrell Edward Morris, and to see him. Tyrell Edward Morris, date of birth being December 28, 2011, and participate in his life. Furthermore, I want to appreciate you all constantly trying to run and ruin the time on the clock, quote unquote, and this circumstance and this situation. I want the information I asked for, and you have not sent it. And since Michelle Lane isn't wanting to email, doesn't mean not to. More, do not try to use your so-called complaint process now to avoid what's real. I do not have to keep starting at step one, that process. You won't keep trying to fail me, having me repeat myself straight up. I have other emails here about her disregarding what I'm saying. Again, I have the FBI attached to this, the governor's office, your office, the clerk of the whole circuit court, the backup of MM, all kinds of people attached to these emails, okay? I knew that they were running the clock, so this is what they did. After so long, Chelsea Ghost says that she could actually agree to an appointment from all the way from July. Also in July, I told her I don't agree with the messages that she this department is a lot of dishonesty and it's exaggerated. She said, this was before court that day, and she said to me in email that she wants to know what was wrong, Judge Jody L. Meyer, and she would correct it. I said, okay, I wrote her along with everything, and she never replied again about the matter. I even talked to her, she said, talk to the judge about it, you were the only one, but you told me that they are the one, that the Division of Children and Family Services are the one. So I said, Judge Jody L. Meyer is being fake, and you're not doing your job. This is what I said, I keep it real. I said, how you sitting up there in the seat? Maybe you need to sit in the beauty parlor, because you know better. I said, Judge, Tony Evers hired you. You were not voting in. This job was entrusted in you. And for Chelsea Ghost to be dishonest with you and trying to make it seem like she is having some kind of psychological war or whatever to mislead the court is a crime. Okay? She did not reply to me or anything. I have so many email correspondence that I have been literally trying. And you know what they did? Okay, there's a meeting, finally, right? To discuss to meet with my son, to see my son. But then, then Michelle Lane said it wasn't about meeting with my son. Michelle Lane said that meeting was to discuss a complaint. So they never had an intention, Division of Children and Family Services never had an intention for me to meet with my son. They were not ever trying to discuss my son. And then all of a sudden they come with these orders. As far as the state of incarceration. I don't have to. I do not also, it's a violation of HIPAA and other things for them people to try to have me, to have some kind of psychological experiment on me and the spiritual warfare and mass incarceration and genocide. I'm not getting on any medication. I'm not gonna have them dumb me down. I'm also, the district attorney had called me, but my phone number had changed, okay? The reason why I did not make it to that meeting is because I was arrested in Mount Pleasant, Wisconsin, at the AT&T store. Judge Jody Elmeyer, I went there and I found that those men that were working in the AT&T store were stealing money. They stole swiped my card 4 times and called the police on me and kicked me out the store and did not give me a phone, okay? When I found out, I tried to go to Metro PCS, and it was the day before I had to meet about my son. That was very suspicious, okay? All of a sudden, this all comes up, and then I went to jail for trespassing. But the thing, they said I was trespassing, that's why they arrested me. But I was on a public sidewalk. I was not even in the store. But what they said was disorderly conduct. They said I was yelling at customers. I have the whole thing recorded. It was all a setup. Mass incarceration. I called the police and I want to make a police report about those people stealing my money. On that Wednesday, I went there because I could not miss this appointment. They refused. AT&T store in Mount Pleasant, Wisconsin, refused to sell me a phone at the full price. That it was like $90-some odd, okay? The man said he is not selling me a phone, and that his manager wanted me to come back the next day and get the phone for free. What kind of business would do something like that? So I came back the next day, and that man gave me a really difficult time about my phone. I have the notes in here about the whole situation. It was terrible. He swiped my card just like the man the previous day had swiped my card multiple times and did not sell me a phone. I said, they tried to get me agreed to pay them $50 and I was not supposed to give the store any money other than $15 activation. They wanted me to let them swipe my card again, so I suppose they wanted me, I'm just assuming, that they wanted me, Jasmine Renee Davis, to agree to the money. They had sold over $120, and I was only supposed to pay them $15 and get a phone. So he said that he is going to take $50 plus the $15, but then for automatic bill pay, that AT&T from wherever they do it in corporate or whatever, we're going to also swipe it. I said, no, you're not. I said, AT&T is the only one that's supposed to swipe it immediately. You're not supposed to take $50 from the store. You're only supposed to take $15. And so then he said, well, he doesn't want to sell the phone now. I said, please. I started crying. I was very soft-spoken. I was crying to the point where if I wanted to scream at that point, I was just so hurt because I want my son. And he said, call the police on me. But I have found that he has stolen the money from me. And so I went to jail. I'm out on bond. That is not Chelsea Goat's business or whatever. I want to tell you, because of the mass incarceration and so much stuff decided. Now, this case, when I was chapter 51 already through false imprisonment. The very next day for custody placement, I was not notified of the court hearing. I was right there in Rogers in the state of Wisconsin's custody. I was not told. Why was I not? No one else except Derek Lewis, Divine's biological father. Divine Davis' biological father was the only one there. Just so happened Chelsea wanted to talk to him and not me. She said I have been combative. She said I have been abusive. I have tried to talk to Chelsea Goes many times. I have even asked for her to step off of the case because she is refusing. She tries to dictate me. She tries to have things happen that are not supposed to happen. She is even said to me something about my mom hitting here something over 30-something years ago and trying to hold that. She talked to me and I talked to her about that in court. She started biting her fingernails. I don't know why she started biting her fingernails, but she said that I was abusing her. I talked to Chelsea Ghost. I said, "You're not my slave master," and I'm the one who initiated those conversations in jail. Chelsea Ghost did not. Chelsea Ghost refused to meet with me. I sit there and read through these papers. It takes hours to go over these paperwork. Chelsea Ghost is seeming very lazy. Please,
When is your
unprofessional.
next appointment with her?
I have an appointment with Chelsea Ghost coming up on the 17th of February.
So a week from yesterday, so next week, Monday, and what time is it?
You know what? I don't even have the time. And you know why I don't
let's
have
ask.
time? Because I'm gonna look at it later. I was literally disregarding that time at the time because I asked Chelsea Ghost to even meet sooner than that previous date. I've been asking them, can I meet sooner? Can I do all this stuff? They never, Division of Children and Family Services did not have an intention. I told you, I said, you know everything that you're supposed to do so that I can get my parental rights taken from me or so that I cannot see my son. And you are going to do that because I am trying, but you are writing everything about me that I'm not doing. She's saying I'm not doing right. So I'm going to keep it real and be who I am.
Okay, let me stop you for 1 second. Ms. Goetz, when is the appointment, date and time and location?
It is Monday, February 17th at 9 a.m. at the Kenosha County Job Center. The address 8600 Sheridan Road.
Okay.
Okay, so I'm meeting with her virtually. I had called to the Kenosha County, Job Center, even in summer, I had recorded calls. They somehow said that they were ordered to tell me not even to call there. It has been so much hardship that they're refusing to even let me call to the building. I called Samantha Curtin. I'm not playing.
Is this an in-person meeting or is it
Virtual. Because she always say
Just let me ask her.
She's been given the option of it can be in person or virtual. If it's virtual, we need to be let known that by her, and hearing that today, then I can switch it to virtual.
So is that what you would like that meeting to be, ma'am, virtual or in
Actually,
person?
if it was a capability where somebody, if they were honest enough, then I would meet with them before the court, or I can meet with them at a place of my choosing. But right now, I think that so that she can learn about me and learn who I am, I would prefer to meet with.
Okay, we're gonna take 5
What?
minutes.
Okay, sure.
5 minutes.
Let them have a break. I'm fine.
Just so you know, the emails were filed, it just popped up in the court about half hour ago. I can email them to you if you want.
I can email, I plan to submit some more, and then I can follow, I'm gonna file some more, but I don't know if you're talking to me, but I plan to file more emails as well. And I'm also planning to file them, with a court case, a criminal case as well, please. My labor, my labor, my labor. My labor, my labor, my labor, my labor, my labor, my labor. Oh, my labor, my labor, my labor, my labor, my child, my autistic. That's what this is about. My son is not gonna always be autistic. He can grow. I have so much. My labor, he is himself. My labor. My labor, my labor. My labor. My labor, my labor, my labor, my labor, my labor, my labor. Well, 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 well. Well, 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 my labor, my labor, my labor, my labor. My labor.
Pam, will you sit down, please?
What is it about?
What do you think?
To the prison pipeline, very awful when it's present in the city of mine. Oh, yes, it is. My, I'm not playing around my mind. Trying to take this case as far as it can go. So you might get paid a little more, but you're not stealing my personality from me.
We'll get through this. Thank you. All right, we're going to go back on the record. We'll just take a 5-minute break here. So it's obvious to the court that there's a lot that Ms. Davis is very unhappy about as it relates to DCFS, Ms. Goetz, and I'm not commenting on that because that's beyond my purview for today's hearing. We do have an appointment, we being, I shouldn't say we because I'm not part of that, but Ms. Goetz and Ms. Davis have an appointment set up on February 17th, that's next week, Monday at 9 a.m. at the Kenosha County Job Center, or it can be virtual. Ms. Davis, could you just confirm with me, ma'am, if you wanted that meeting to be in person or virtual?
I actually was still making my statement.
Yeah, no, I'm
I'm
stopping you. I want you to answer my question.
Sure, I know, but I had that to make for the record actually, but sure, because it.
Virtual or in person?
So, I am going to meet with that person at Department of Children and Family Services, virtually.
Okay.
And that's only because I would like to meet with, in person because that's good, but every time it has been said that I have been abusive and I am not alone.
Okay. All right. It is
I
clear.
will abuse it.
Stop this. It's clear that, again, there is not a great relationship between the mother and the division. But there's going to need to be, Ms. Davis needs to work with the division if she wants to reunify with her child. I said this at the beginning of the hearing, and I'm going to state it again. Based upon the requested permanency goals, nobody is motion to terminate parental rights of Miss Davis to Tyrell. And so hopefully that will, at least at this time, but that there's no long-term goals about that. Although at these hearings I read termination of parental rights warnings, I'm obligated to read those to any parent whose child is not living with that parent and has been removed from the home, so to speak. But even though again, at the end of this hearing, I'll be reading those again, the goals here, there's no goal to terminate parental rights at this time. And that's what I'm dealing with here today. I do need there to be progress made towards reunification. That's still a goal that is on the table, and that's the court's going to approve that in a moment. But I can't do the work for any parent that comes in this court. And Ms. Davis, I'm going to encourage you to put aside the bad blood that you have with the division.
Oh, I don't have any bad blood.
Stop,
ma'am.
please stop, don't interrupt
Well,
me.
no, not-
Don't interrupt
you have to
me,
speak on
don't
my blood.
interrupt me, don't interrupt me,
speak on
don't
my blood.
interrupt me, don't interrupt. And so I need you to work the conditions of return that have been put in place so we can ensure a safe return of Tyrell to you. A hearing was held today regarding the permanency for Tyrell. I have reviewed the filed plan. I do find that the provisions of the Indian Child Welfare Act do not apply. The permanency goal for the child has been returned to the home. The goal does continue to be appropriate. The concurrent permanency goal for the child has been placement with a guardian. That goal also continues to be appropriate. It is appropriate to have a concurrent permanency goal at this time. The permanency plan has been complied with by agency and service providers, not by the parents at this time. I know the mother has issues with DCFS, but she does need to be engaged with services in order to reunify, and the placement of the child continues to be necessary, safe, and appropriate. Adequate efforts have been made to involve the appropriate service providers in meeting the needs of the child and the parent, but sufficient progress has not been made in eliminating the causes for the out-of-home placement. And Tyrell's been out of the home for 15 of the most recent 22 months, so I do find that the permanency plan is appropriate, and that permanency is likely to be achieved by August 11th of 2025. Reasonable efforts to achieve the permanency goal of the permanency plan were made by DCFS through their case management, parenting education, mental health referral, random urinalysis, life coaching referral, care for kids, and CLTS services. There are no siblings in out-of-home care, so at this time I am going to order that the permanency goal for this child remain returned to the home, as well as concurrent permanency goal remaining placement with the guardian. The department shall timely file an updated permanency plan with the court to accommodate the next permanency hearing date.
August 11th at 1:30.
Possibly do it in the morning.
11th?
Yeah.
August 11th at 11.
Yeah.
That will be the next permanency review, and we'll see what progress has been made at that time. And hopefully the meeting on the 17th will turn the corner and get some progress made, which would be a good thing. Also, on the request to revise the dispositional order, a hearing on the request was also held today, and I do find the allegations of the request are proven. I definitely was finding the fact is there's been a lack of contact here with the division. There's some concerns about stability and what going to order that the request for revision be granted. I'm going to take that, however, in a moment. As it relates to the termination of parental rights warnings, like I stated just a moment ago, I do need to read these to any parent whose child has been removed from their care, even though at this present time, termination of parental rights is not one of the permanency goals. But the parent needs to be aware that your parental rights can be terminated against your will under certain circumstances. A list of potential grounds for terminating your parental rights will be given to you in writing as part of the order. There are boxes that are checkmarked that are the grounds that may be most applicable to you, although you should be aware that if any others exist now or in the future, your parental rights can be taken from you. The first one is abandonment, which is a ground that is proven by evidence that you have failed to visit or communicate with your child for either 3 months or longer after your child has been placed or continued in a placement outside of your home by a court order, or 6 months or longer after leaving your child with any person you know or could discover the whereabouts of your child. Next is continuing need of protection or services, which is a ground that is proven by evidence that a court placed or continued in a placement your child outside of your home after a judgment that your child is in need of protection or services under Chapter 48 of the statutes, and the agency responsible for the care of your child has made a reasonable effort to provide the services ordered by the court. Your child has been outside of your home for a cumulative total period of 6 months or longer under a court order and you failed to meet the conditions established for the safety of your child to your home. Next is failure to assume parental responsibility, which is a ground that is proven by evidence that you are or may be the parent of a child and you have not had a substantial parental relationship with the child. Next is continuing denial of periods of physical placement or visitation, which is a ground that is proven by evidence that you have been denied periods of physical placement by a court order in an action affecting the family, or have been denied visitation by an order under Chapter 48 of the statutes, and at least 1 year has elapsed since the order denying periods of physical placement or visitation was issued, and the court has not subsequently modified its order so as to permit you periods of physical placement or visitation. The conditions of return remain to maintain a suitable residence, cooperate with DCFS, have regular contact with your child, actively participate in services, actively participate in and cooperate with all educational and medical planning for the child, provide for the financial needs of the child, and the specific condition about the completion of the psychological evaluation and comply with recommendations made. And if there is a recommendation to engage in counseling, then the parent needs to participate in the counseling on a schedule determined by a therapist and comply with recommendations of the therapist, as well as actively work towards meeting the treatment goals in therapy. Now, although I just stated that one of the conditions of return are to have regular contact with the child, I need to get the psychological evaluation done. I need to have progress as well on these conditions of return. And that's where the focus needs to be, not on the grievances with the division. And so these are the conditions to reinstate visitation. That there's going to be no visitation until the following preconditions are met. That
Can you speak up, please?
the mother will cooperate with DCFS and will attend 2 consecutive meetings with the assigned DCFS caseworker. This is for Ms. Davis to demonstrate cooperation, discuss visitation planning, that she can be consistent for her child. Next is that she needs to complete the psychological evaluation. That's where I'm going to stop the request. I know that there's a lot more where the division wanted the request to continue. The period is going after complete the psychological evaluation. We'll go further after that, but that's going to be the precondition itself.
What are you saying?
And then next that Ms. Davis will write her child 1 letter each week for 4 consecutive weeks and provide that to the assigned DCFS caseworker so she can demonstrate she can have consistent, appropriate contact with the child. The letters shall not include any promises to the child or any information that is not appropriate given the child's age and development. And a court hearing must occur prior to the reinstatement of visitation, which I certainly will get on in very short order when that need arises. So your visits are suspended until you follow through with meeting with the DCFS caseworker, like I just said, ma'am, for 2 consecutive meetings. Your first one is on Monday, so make sure you keep that one. And then the letters to your child, as well as the psychological evaluation. I need you to be forward-thinking and look at what you need to do to reunify, even though I understand and I've heard all of your grievances.
No, you didn't.
I did.
I did
Well,
not
you
have
might
a
have a
grievance.
lot more,
You
but
know,
that's
I
not what
said
this
something
court
and I
hearing is
did,
for, so
but
that
you
will
are-
conclude the hearing today.
You go ahead, you disobeyed the law. And I did not speak, and you know that she did not cooperate with me with this permanency hearing. So you said it's off the record, right?
Orders are-
Good. So you all are committing a crime, and I do not have to, and what you're trying to do is kill me, and I'm not taking it. And even though you might sit on there, you have immunity, and they think they got some too. But Jody Elmire, you know you wrong. And you had that boy to throw that tantrum on purpose. Now, Chelsea, you're going to have to stop being dishonest. You're going to have to stop being dishonest.
Let's just grab our stuff.
You're going to have to stop. It's some paperwork that's coming that I'm not signing.
Let's just start
No,
gathering your
no, I'm sitting at this place. You may not commit a crime.
dates.
No.
They give you the paperwork?
No.